All right, it's 9:48 past time for the South Coast AQMD Hearing Board meeting today. We have 3 cases on the docket. We have four cases on the docket. Yes. Okay, one second. Okay, here we go. We have 4 cases on the docket. Just for the record, one matter is off. This calendar has been rescheduled. The South Coast AQMD versus Valley Plating Works in case number 6259-1. And just for the record, we convened at 9:47 a.m. Yes, the 6259-1 order of abatements were scheduled to 11/19/2024. Okay, the cases on the docket today are all on consent calendar. SpectraSite Communications LLC Los Angeles 6261-1, SpectraSite Communications LLC House in the Heights 6261-2, California Tower Inc. 6262-1, the South Coast AQMD versus Los Angeles City Sanitation Bureau Hyperion Water Reclamation Plan case number 1212-39. Are there any individuals who are desirous of providing public comment relative to non-evidentiary testimony? Okay. And so just for the record, there are no individuals desirous of providing non-evidentiary testimony and or evidentiary testimony, Madam Clerk. Okay, so we're very clear. No one is online. Just want to make sure for the sake of transparency and to ensure that the public is included in the hearing process. All right, the first case that's before the hearing board is case number 6261-1 on consent calendar. The exhibits have been marked. And just for the record, we will go through those exhibits. So the first exhibit will be the stipulation to place matter on consent calendar. That's exhibit number 1. The second exhibit is declaration of Angela Robertson, 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 exhibit number 2. Third exhibit is declaration of Jennifer Mulkern, Mulkern, is exhibit number 3. Exhibit number 4 is proposed findings and decisions and order granting regular variance. I'd like to open up the floor for discussion and or comments from members of the board. Mr. Pierman?
Yeah, we saw.
I'm sorry. And then we have HB1. HB1 is the Balaka Palan email dated Tuesday, September 10th, 2024, 10:36 a.m. with responses to questions for 6261-1, 6261-2, and 6262-1. Okay, Mr. Pierman, I apologize, sir. The floor is yours.
Sure. We dealt with this before on an interim, I think it was August 6th, and certainly they have grounds for the variance, meet the 6 findings. There was a trespass who caused a problem with the communication equipment exceeding the allowable runtime, and so I think we'll be able to find and support the stipulated order. I also note that when we do so, we'll just for the record note that the proposal at number 4 includes Ms. Verdugo Peralta as present, so we should make sure in the final version we correct that.
The chair has indeed noted that. Any further discussion? Mr. Balakapalan, the floor is yours, sir.
Yes, I think agree that we can also I can also make the 6 findings. I also want to note that Ms. Jennifer Nuland did revise the excess emission calculation, separate out the pollutants, and the revised condition based on my comment exclude the PSPS hours that was initially proposed.
Any further discussion? Hearing none, is there a motion?
Yeah.
Mr. Balakapalan, the floor is yours.
Sure. In the matter of SpectraSite Communication LLC, case number 6261-1, I move that we grant a regular variance commencing today and continuing through December 31st, 2024 from Rule 203B, and specifically condition number condition number 4, or for the equipment that is permitted as one, I listed that, a G66246, which is the internal combustion engine, diesel fired. And it's you got it? G66246. And it's located at 2915 East 12th Street, Los Angeles 90023. The conditions are as in the revised finding and decision document. And the excess emission, I'll read it out because it's been changed, and it'll be the same for the others because they're identical. Slow down, sorry. The excess emission for NOx is 18.57 pounds per day. For the non-methane hydrocarbon is 0.98 pounds per day. The CO is 4.16 pounds per day. And PM is 0.83 pounds per day. Do you mean, repeat it? I know I was going too fast. 18.57 for NOx. The non-methane hydrocarbon is 0.98. The CO is 4.16. The PM is 0.83. And these are the excess emissions, yes. And with that, I conclude my motion.
Is there a second?
Second.
Some probably moved and second. Any further question or discussion on the motion? Hearing none. Dr. Abraham.
I vote aye.
Mr. Velakapalan.
Aye.
Mr. Freeman.
Aye.
Ali votes in the affirmative. The matter is hereby passed. The order is hereby, the regular variance is hereby granted. Next case, 6261-1, 6261-2 rather. All right, the exhibits are hereby as follows. Stipulation to place matter on consent calendar is exhibit number 1. Declaration of Angela Robertson is exhibit number 2. Declaration of Jennifer Mulkern, exhibit number 3. And I do believe that concludes the exhibits. I'm sorry, proposed findings and decisions and order granting regular variances, exhibit number 4. Any discussion? Oh, and HB1 is a Velakapalan email dated Tuesday, September 10th, 2024 at 10:36 a.m. relative to responses to questions for 6261-1, 6261-2, 6262-1. Discussion, deliberation.
Yes, again, this is very similar to the other previous case. They came before us for an interim variance, which we did not approve. So now this is before us for regular variance. The only change is based on my comments, they modified 6261-1, but inadvertently did not modify the condition number 5 in this case for 6261-2. So do need to make at the appropriate time when I make the motion, I was going to suggest we revise that condition number 5. Other than that, the situation is, again, there was a problem with the automatic transfer switch. The engine had clearly exceeded the 200 hours. They do need relief to continue to repair and operate in case of emergency, the IC engine. So, and they made all the requisite 6 findings in the declaration. So, except for the excess emission, as I cited, because it's identical engines to the other, the previous one, they're the same, except condition number 5 has to be revised because they've exceeded the 200 hours. Rule 118.1 says you subtract from 200, not 220 or 240, for the PSPS hours. So for that, so condition number 5 has to be revised, as I indicated, to remove the last paragraph in condition number 5 at the reference to where it says petitioner may exclude any hours the IC operated for public safety, public shutoff, as defined by Rule 118.1 and henceforth, that whole paragraph should be removed, as in the previous case.
Okay, so we just want to make the motion to clean this up?
Just a comment, this case and the next, the Cal Tower, what's interesting is they use the term malfunction runtime when the generator operate by some mistake, not for testing or whatever. So we had this situation in SoCal Gas, where we determined that that error shouldn't have counted as testing. So these parties actually have a category for malfunction runtime where it might have been started for testing mode, but it got stuck. And so therefore the rest of it was malfunction runtime. So I think that analysis supports how we handle that, and perhaps something that the district should be aware of, that if there is that category, then you can use that to justify our rule in SoCal Gas. So just to point out that they actually did it like that here with that separate category.
Any additional comments? All right, is there a motion to also clean up the other concerns as broached?
All right, I'll go ahead and do it. In the matter of SpectraSite Communication LLC, case number 6261-2, I move that we grant a regular variance commencing today and continuing through December 31st, 2024 from Rules 203B and condition in number 4 of the permit G65402 for the equipment that is located at 17047 East Gale Avenue in Hacienda Heights, California 91745. The condition as in the proposed finding and decision document, with the change to condition number 5, with the removal of the last paragraph with the reference to the PSPS hours. Yeah, exclude that, that last sentence in that condition number 5. The excess emission are as previously cited in the previous case. So with that, I conclude my motion.
Is there a second? Second.
I second also. I'll just point out again for the clerk to strike Ms. Verdugo Peralta as being here for the order.
Okay, moved by Balaka Palan, seconded by Dr. Abraham with an amendment as proffered by Mr. Pearman. No further discussions relative to the motion. Dr. Abraham.
Aye.
Mr. Balaka Palan.
Aye.
Mr. Pearman.
Aye.
Ali votes in the affirmative. The matter is hereby granted. 4-0. All right, moving on down to the next case is 6262-1. The board shall consider whether to grant a variance for more than 90 days. The rule in question is Rule 203. We'd like to open up the floor for this. Oh, just very quickly, let us take care of the exhibits. 662, okay, put this here. All right, so the first exhibit, since it's right in front of me, is HB1. HB1 is the Balaka Palan email dated Tuesday, September 10th, 2024, 10:36 a.m. Responses to questions for 6261-1, 6261-2, 6261-2, 6262-1. First exhibit is the stipulation to place the matter on consent calendar. The second exhibit is declaration for Angela Robertson. The third exhibit, sorry, that's second. Okay, the third exhibit is declaration from Jennifer Mulkern. Mulkern, and then the fourth exhibit is findings and decisions in order granting regular variance. Discussion. Mr. Balaka Palan.
Well, they did come before us for the interim, but they did withdraw that case for the interim variance based on what was happening to the prior 2 cases at SpectraSite Communication. It's from the same representative, the attorney, and I think the same company owns all the 3 sites. So again, this is again an engine. I think it's a malfunction, and they need to repair, and the runtime exceeded 200 hours. So they do need relief to operate the engine, one, to repair it, and to run it on an emergency basis as needed till the end of the year. So I'll refer to the 6 findings that they made. I agree with the findings that they made in the declaration that this is beyond their control. I mean, they're in violation of the Rule 203B. They've exceeded the hours. That non-compliance is beyond the reasonable control due to malfunction of the automatic transfer switch. The closing would be without a corresponding benefit, reducing air contaminant. And they've given consideration curtailing operations, so they'll run it only for testing and maintenance to the end of the year, unless an emergency occurs. Petitioner will reduce excess emission by running it only 1 hour a month. And the petitioner, and all the last thing, they will monitor and quantify emissions, which this is identical excess emission as previous 2 cases because the engines are of the same size. So I do believe I make the 6 findings and I can make the motion to grant the variance, the regular variance in this case.
Any further discussion?
I concur, and I assume that you would strike that last sentence of paragraph 3 again, and also, again, if we grant this motion to reflect that Ms. Verdugo Peralta was not present in the decision order.
Yeah, I was just going to add that they did and a revised one with that removed. It's only they didn't do it for the previous one, so they did remove it.
It's not in our packet.
I think it was probably in the email, I think the package was an earlier copy, so that's why it wasn't there, but it has been removed.
All right, the floor is yours, sir, relative to the motion.
Okay, in the matter of, it's California Tower Incorporated, case number 6262-1, I move that we grant a regular variance commencing today and continuing to December 31st, 2024, from Rule 203B, condition number 4 of the permit G5553 for the internal combustion engine diesel fired located at 6427 Oak Canyon Road in Irvine. For the conditions are as listed in the proposed finding and decision document. The excess emission as previously cited for the other case for all the pollutants, and that's it. That concludes my motion.
Second. It's been properly moved by Mr. Butler Kaplan and seconded by Mr. Abraham. Any further question or discussion on the motion? Hearing none, Mr. Abraham, Dr. Abraham, rather. Mr. Butler Kaplan. Mr. Pearman?
Aye.
Butler
Oh, I'm
Kaplan,
sorry.
captures your vote?
Aye.
Aye, Ali. In the affirmative, the matter is hereby approved unanimously. And we were moving on to the next case, which is case number 1212.
Can we, let's check, sorry, take a moment so we can gather the case.
No problem. Mr. Day, we'll take a 5-minute recess. We're off the record. We're off the record for 5 minutes, Madam Clerk, so we can gather. Oh, you good? Okay. All right, Mr. Day, the recess wasn't needed. We're going to reconvene.
All right, here we go.
All right, the recess was not needed as initially thought, so we're gonna move down to case number 1212-39, which is a matter before the board dealing with the status report / modification order for abatement. On the consent calendar, the exhibits are as follows. And just for the record, if the public is following or reviewing this after, this case is before the board. And so as the other ones were exhibit number 1, because of the numerical sequence, this case has been before the board on numerous occasions. And so these exhibits will be as follows. Stipulation to place matter on consent calendars, exhibit number 10. The next exhibit is a proposed findings and decision for a modified stipulated order for abatement is exhibit number 12. The floor is now open for discussion and deliberation.
11.
Yes, I'm sorry. Declaration of Sherry Simons was 11. Sherry Simons was 11. So 10 is stipulation to place on consent. 11 is declaration of Sherry Simons.
Mr. Chair, I did have some comments.
Go right ahead, sir. The floor is yours.
No, I mean, I did provide an email with comments. I don't know, as hearing about exhibit that needs to be marked. So, and they did revise based on my comments, a couple of things.
Okay, Madam Clerk, we have that as HB? Okay, all right, so we'll come back for the record. We'll come back and we'll address the Balaka Palan exhibit. So we'll move on to deliberation and discussion. Are there any comments relative to this matter?
Nothing to add. We've had this before us in the past, and they're working on the flares as stated. I know my appearance is subject of other issues, but it seems like the flare replacement project is going on apace. Only comments on the exhibit 12 proposed order includes, again, we referenced that granted the admission of Ms. Verdugo Peralta, and they gave an option for the next hearing of either October 8th or October 9th, 2025. And given that it's so far in advance, I really have no preference at this point as to which date we put, but I guess we either can pick something now or the clerk can determine it at a later date. I'm indifferent.
It's October 5th, what they say?
Because it's October 8th or 9th, 2025. I was looking at 2024, but I
Yeah,
assume that's what
exactly.
I meant, yeah.
Okay. Yeah, he was commenting on the date, and so we'll wrap it up into the motion, and I'll go ahead and make the motion on the matter of. Oh, go right ahead, Mr. Balaka.
I do want to. I previously voted. Sorry, I previously voted no on this case, and I still want to register my concern that, and I did provide some my comments on the reasons why I voted no, and I still, because they did the source test as scheduled, but they still haven't got the report. One of the reasons I voted no is to get the results of the source test. So the district has it, they still have not provided whether they're in compliance. So I think preliminary indication, Mr. Simmons indicate they probably, most of them are not going to meet it, but there's no official record yet from the district after the review of the source test. They are meeting no. The other thing I wanted to point out is this is going to be probably another 8-9 years before we see the construction completed. Just they said they'll submit the application for the flare in 2027, and they expect another 5 months before construction starts, and the costs anticipated is about $124 million. I think the comment I made before too was, and maybe I didn't make that, is what I was going to say is this, and I did ask the engineer when he was here before, why this was all permitted as a flare system. It's not individually, because, and I think the district may want to look at maybe separating out each of these permits individually for the flare, so they could make, if there's some flares that are in compliance, they may be able to continue operating it, and the ones that are not in compliance may need to be replaced. But the other comment I made was, was that there was an exemption in the rule, and I'm not sure if anybody looked at it, but I did put that in my dissent comments last time. So I want to, because I think the cost is $124 million, and I have no idea on the financing or anything like that. It just seems, for me at least, when I see it high, there's more immediate things that the facility needs to do to repair. We have heard from the last case that there's still ongoing complaints from the community, and I believe most of it is related to fugitive emissions coming from the plant, which is all that needs to be upgraded and so forth. The money, and again, again, I need to emphasize, I have no idea on the budgeting or anything like that, and maybe they'll have a lot of money and it's not an issue. But I think the money should be more spending right now on improving the infrastructure, improving all the fugitive emissions and repairing those, and see if they can delay. Well, they're going to delay the flare, whether they need to replace all the flare. Anyway, so I'm going to still give the same reason I cited before and vote no on this.
Thank you, sir. We do have the exhibit. It's HB1. The exhibit was sent by Mr. Balakapalan Friday, September 6, 2024, 3:05 p.m. There's communication back between Mr. Balakapalan and the clerk's office relative to this case. So just for the record, this will be added as HB1, and the document will be included within the record. At this time, I'll go ahead and proffer a motion in the matter of the Los Angeles City Sanitation Bureau Hyperion Water Reclamation Plant Facility ID number 8000214, case number 1212-39. I move that we find good cause to grant an order of abatement as set forth in the proposed findings and decisions, exhibit number 12, with the following redactions: that of the name of Cynthia Verdugo Peralta, who is not present, and set a hearing date for October 8th, 2025 at 9:30 a.m. Is there a second?
Second.
Second by Dr. Abraham. Any further question or discussion relative to the motion? Hearing none. Dr. Abraham, how do you cast your vote?
Aye.
Mr. Balakapalan?
I would no, and I'll add a couple more comments when I sign it to my dissent.
No problem. Mr. Pearman?
Aye.
Ali in the affirmative. The matter is hereby approved, 3-1, and one who is absent. All right, at this time, we will go ahead and recess until, well, as a matter of fact, no, we're done. We're done. All right, folks, we thank you for your time today, and we thank the staff immensely for working very diligently on gathering all these documents, and there was a tremendous amount of paperwork and printing of copies. So we're hereby adjourned at 10:16 a.m. and off the record. All right, so we have the chair guy coming around 11 o'clock. Okay. Come do the assessment, boom, boom, boom.
That's someone who's always here working with you?
No, there's a vendor.
Okay.